Our client was about to be robbed and assaulted, that there were two individuals, the two individuals that were deceased, one of them had a 9mm in his hand that was jammed. What happens when guns are jammed, right? You have to pull the trigger and then it doesn't discharge, all right? So that's proof positive right there. He's acting in his defense. He's acting in defense of this other woman that was driving the vehicle, and he's acting in defense of the vehicle that they're in. That's a triple layered immunity. And the only counterpoint to that is it's a felony amount of marijuana, which they can't prove. You're justified in using force that is likely to cause death or bodily harm when you feel that an individual, you reasonably feel that an individual is trying to use that same type of force against you. And so basically, if in a life or death situation, you can choose that, hey, I have the means to live, I'm going to live. That there is a caveat. The caveat is that if you're in the commission of a felony, then you cannot avail yourself to self-defense concepts, because the theory is because you're committing a felony, you can't access that, all right? The issue in this case is whether or not my client was committing a felony or not. And the way that we test evidence in Georgia and in every state in the union as regard to drug evidence is it's sent to the Georgia Crime Lab and it is tested to see if it is a felony amount, or with the new hemp statute that we have here in Georgia now, there has to be enough THC in the green leafy substance to distinguish it and make it marijuana versus it being hemp. What my point is, and it's not a point that's going to change, and it's not really the difference between, is you can say that it's a closing argument to a certain extent, but the same argument is good now, and it's going to be good later, is that without the substance, you can't tell whether it's a felony or not. And you're never going to have the substance. So you're never going to be able to tell whether it's a felony or not. So if you're going to take this defense away from this young man, where he basically decided to live where two people were trying to rob and kill him, and he saved another elderly lady there who was in the vehicle, then you have to prove that what he was doing was a felony. And you can't just go off of what he says, right?